Good evening, everyone. I'm Kerrie
Meeting
Blaise
is
from
boarded.
the Canadian Environmental Law Association, and it's our pleasure to be here this evening. And thank you to the City of Dryden for the invite. I'm joined this evening by Theresa McClenaghan, who is the Executive Director and also Legal Counsel at CELA. And this evening we have probably about an hour-long presentation for you where we will addressing the question of nuclear waste and coming at it from an environmental justice perspective. So the Canadian Environmental Law Association, just to give you a bit of background of who we are, where we're from, we are a public interest law organization dedicated to environmental equity, justice, and health. We were founded in 1970, and we are the only legal aid clinic in Ontario that provides free legal services to low-income people and disadvantaged communities with financial support from Legal Aid Ontario. We represent clients in a range of matters, including public legal education events, such as tonight's event, but also summary advice and representation of clients on a range of matters which are aimed at protecting human health, air, land, water, and nature. And at CELA, we advocate for greater access to environmental justice and the prevention of pollution in order to protect public health and safety. And so our work places a high priority on cases and law reform work, which is aimed to ensuring access to environmental justice and safe, healthy, and livable communities. And you're welcome to check out our website at cela.ca, and you can learn more about our services, which again include the direct representation of clients in court and in proceedings, summary advice such as, if someone is looking for environmental information or how they can be involved in their community on a certain environmental issue, we can help you out with that. And we also provide public legal education, both in webinar form, when health policy permits, in person, and also we have a number of resources and fact sheets and briefing notes on our website. We're also engaged in a lot of law reform efforts, both at the provincial and federal levels, to environmental justice. And so today's focus is actually in response to a number of questions and comments we get from individuals and communities who are looking to learn more about how to participate in an environmentally significant project that's occurring nearby or in their community. And so we're pleased to be here this evening so we can better understand what is Canada's plan for radioactive waste, and what does that mean if you're the Nuclear Waste Management Organization and if they are looking for a willing host. And so this evening, we're going to review the many players, the many roles, in order to understand how members of the public can have a voice and can be involved. This means we will review some key terms like what is a host and who is willing. And we'll also look ahead to provide a snapshot of what key decision points are going to be made where you can be involved. And so here's our agenda for this evening. These slides will be posted, so we're hoping that they will be a resource for you down the road. And so we have 7 parts this evening. We'll start with some background information about Canada's plans for nuclear waste. We'll review the roles and the jurisdictions. We'll also look at how the public can be involved and what international nuclear law and guidance tells us about the role of the public. We will highlight a number of questions and uncertainties you may want to raise and ask, and we'll help you in addressing those areas of uncertainty. And we'll conclude by looking ahead. What's yet to come? What can you watch for? And of course, we will conclude with a questions and answers session, and you're welcome to follow up and ask your question then. And now I will turn it over to Theresa.
Great. Thank you very much, Kerrie. And thank you, Dryden, for inviting us. I'm speaking to you from Paris, Ontario, which is in Southwest Ontario in the Grand River Valley, the traditional, ancestral, and current home of the Six Nations of the Grand and the Mississaugas of the Credit. But I spent my childhood in northeastern Ontario and Western Canada, and I am also, as Colleen indicated, very pleased to acknowledge the long stewardship role that our Indigenous friends, allies have played over millennia safeguarding these lands before us. So starting with the context for today, and the topic of Canada planning for nuclear waste, we have had commercial power production in Canada since the 1960s, and the result of that, among other things, is that we do end up with nuclear fuel bundles produced out of all of those plants, and they are considered high-level radioactive waste and extremely important to make sure that they're safeguarded and they're separated from people and the environment for a very long time frame that we'll get into in a few moments. After a number of other processes, Canada enacted the Nuclear Waste Management, the Nuclear Fuel Waste Act, and set up the Nuclear Waste Management Organization. It began a site selection process in May of 2002, after an earlier process developing its adaptive phased management plan. Next slide, Kerrie. Sorry, I just have to catch up here on my own screen. There we go. So as you likely know, if you've been participating in the sessions that I understand have occurred to this point, there were a number of communities who were approached or who put their hands up to be considered. And at the moment, the Nuclear Waste Management Organization is considering 2 potential sites in South Bruce and in Northwestern Ontario. And this image comes from an NWMO publication schematic of the proposal with underground tunnels and rooms about 500 meters deep and covering a footprint of about 2 by 3 kilometers. Next slide. And again, taking this from the NWMO's publications, they've been pursuing a multi-stage process of trying to find a site for the nuclear fuel waste. And at the moment, we're in what they call step 5, where the communities are being considered. There's technical work happening, and communities are being asked if they're willing to take the fuel waste. Next slide. And then just to kind of give you the future context, and we'll touch on this in our presentation tonight, among the future steps would be the if a willing host is found and an application is made to site the project, then there would be an application to the Canadian Nuclear Safety Commission following an environmental assessment. And so that would result in environmental assessment and licensing efforts, which we will discuss further tonight as well. Next slide. So as Kerrie mentioned, there are several players and there are several jurisdictions to think about when we're thinking about who is making decisions and the roles that people are playing in respect of nuclear fuel waste. So the Nuclear Waste Management Organization, as I mentioned, was given the mandate. This is the owners of the nuclear power plants in Canada, and they were made the directors of the Nuclear Waste Management Organization to come up with the plan that they're proposing. And I should add that we won't get into it tonight, but there's a policy consultation underway by the Government of Canada about fuel waste. And one of the things that CELA and other organizations say in that consultation to government is that all nuclear waste should be overseen and managed by an independent agency, not by the owners of the fuel waste. But tonight we're here to talk about the current proposal by the current structure. So that embodies the NWMO. The other another significant player who we'll discuss is the regulator, the nuclear safety regulator, the Canadian Nuclear Safety Commission. And they will eventually, if there is a willing host, be responsible for considering whether to issue licenses for this potential deep geological repository and whether it meets the thresholds for their decision making under their licenses. And we'll get into that in a few minutes. And then there is the Impact Assessment Agency of Canada, which was set up in 2019 when we had new legislation around environmental assessment, and they would be responsible for ensuring the environmental or impact assessment of the nuclear fuel waste proposal was conducted in accordance with that legislation. And again, we'll get into that momentarily. And then finally, we'll be talking a little bit about provincial and municipal decision makers who are responsible for either general law, like planning law, environmental law, or in the case of municipalities, local land use and bylaw decisions. Next slide, Kerrie. So starting with municipal jurisdiction, I want to say that municipal decision-making over nuclear power regulation and oversight is very, very limited. The municipal land use planning, if it were to conflict with a decision of the federal decision makers about the location of a nuclear site or some other matter relating to the operation of the site, would be overridden by paramountcy doctrines by the federal legislation. And this is because nuclear power was declared by Canada to be for the general advantage of Canada, and a number of court cases have ruled that it is a federal jurisdiction as between provincial and federal jurisdiction to oversee nuclear power and everything associated with it. And then municipalities are creatures of provincial statute who have the powers that are authorized to them by the Municipal Act and some other applicable legislation. However, some municipal bylaws may still apply if they're not singling out nuclear in terms of their application, or if they're not in conflict with the federal licensing regime applicable to nuclear power. Next slide. And then we also have a growing and important recognition of the application of long-standing Indigenous law. And some of that law is being recognized within, slowly, but eventually within the traditional court system and common law in Canada, as well as sometimes within statutes established by Canada. And other law is being recognized as rooted in the long-standing Indigenous legal traditions, and many Indigenous communities are pushing forward with making decisions based on that long-standing inherent law. And at the very least, our Constitution and the Charter, the Constitution provides that pre-existing treaty and Indigenous rights survived the introduction of the Constitution and must be respected. And among other implications of that are duties of consultation that have been elaborated by the courts of Canada. could do a whole session on Indigenous law, but we'll leave that for another night. Okay, and then in terms of federal jurisdiction, what is the role of the federal decision makers? So as I mentioned earlier, in contradiction to federal law, provincial law covers some matters like property and civil rights in the province, which means that they could cover water permits or air pollution permits or land use planning or mineral exploration or drilling. But nuclear power, as I mentioned, is considered federal. And so when a conflict arises between these provincial areas and nuclear power, then the nuclear law will prevail to the extent of that conflict. A lot of the time, there is an effort by decision makers and by the courts to make them both operate together. But if a conflict arises, then those federal decision makers operating under the federal legislation would be paramount. And this is an excerpt explaining how it came to be that the nuclear power was recognized as federal jurisdiction, because of course back in 1867, when we first had a constitution in Canada that divided what's called heads of power between the provinces and the federal government, nuclear power was not on anybody's radar, obviously. But there is a provision that when things are for the general advantage of Canada, they can be recognized as federal. And so in the federal law, the Nuclear Safety and Control Act, and before it, the Atomic Energy Control Act, was a declaration that works constructed for using nuclear energy or mining and using nuclear substances would be declared to be a work or undertaking for the general advantage of Canada. And that is what put it into the federal side of the column in the tug of war between federal and provincial jurisdiction. And the reason I'm emphasizing this tonight is that in terms of decisions like land use and siting, it's going to end up in the medium term and the longer term being those federal decision-making contexts that apply. Next slide. And then I mentioned that the Nuclear Waste Management Organization was set up under the Nuclear Fuel Waste Act. This was back in 2002. And the main corporations operating commercial nuclear power in Canada were Hydro-Quebec, New Brunswick Power, and Ontario Power Generation, as it now is. And this industry organization is responsible for implementing the approach to long-term management of Canada's nuclear fuel waste, and it made a proposal called adaptive phased management. And so, as I mentioned, it's the owners of the radioactive waste, i.e. of the nuclear power plants, formerly operating or still operating, who are responsible for funding, organizing, and any other disposal activities relevant to the waste. And we have long-standing concerns about the Nuclear Fuel Waste Act and this structure, some of which are the subject of the policy review that's underway right now by the federal government. And among our concerns are lack of transparency and accountability and control by the industry of the organization and its former advisory council, as well as the absence of a role for Parliament. And we'll get into that over the course of the evening. Next slide. And then we also have quite important federal legislation dealing with environmental assessment, or as it's now called, federally impact assessment. And this is really important legislation which is intended to consider whether any particular proposal is needed, what's its purpose, what are the cumulative effects of that project and any associated physical activities, and what are the alternatives to the project. And the reason it's structured that way is to lessen the project's impacts, to mitigate harm, improve social and ecological conditions, and of course, consider the project in the context of whether it's needed at all, especially once the adverse impacts are weighed against the benefits. And it's quite significant legislation that looks at the physical impacts, like impacts on air, water, land, plants, and animals, as well as human impacts like culture, health, community sustainability, employment, and financial benefits. Next slide. And in addition to minimizing and preventing environmental harm from a project development, the other important roles of impact assessment include looking at whether there would be disproportionate impacts on vulnerable communities and ecosystems, considering the who bears the harm versus who benefits question, as well as providing a forum for public input and public voice. And that became an extremely important part of environmental assessment about 2 decades ago and has been enhanced ever since. Next slide. And so in this schematic, which comes from the Impact Assessment Agency of Canada, we see who are the main participants in impact assessment, which would be a subsequent stage in considering a nuclear waste process. You have the proponent, you have a review panel, federal authorities, Indigenous communities. The minister might have a decision-making role depending on the decisions that are made along the way. The agency itself that shepherds the process along, ensures environmental assessment is conducted properly. The governor and council, that is the cabinet, which may have decision-making roles. The other jurisdictions they can cooperate with, like Indigenous nations and provinces, for example, and the public. Next slide. Okay, I think I'm turning it over to Kerrie for a few minutes here.
Thanks, Theresa. So another of the entities that we'll review for you is the Canadian Nuclear Safety Commission. And so they also have a role. And if you recall the 9-step process that we introduced earlier on in tonight's slideshow, there was a 9-step process, the 5th step being the stage where willingness is determined, and the 7th step being where impact assessment that Theresa just reviewed and nuclear licensing would occur. So again, this is where the Canadian Nuclear Safety Commission would come in, and this comes after a determination of willingness by a community. And so Canada's nuclear safety regulator is known as the Canadian Nuclear Safety Commission, and they were established in 2000 under the Nuclear Safety and Control Act. Their predecessor was known as the Atomic Energy Control Board. And the commission, as a tribunal, they also have staff. They have approximately 800 employees who review applications for licenses in accordance with regulatory requirements. And they also make recommendations to the commission in advance of a licensing hearing. And it's the CNSC's mandate to regulate both the development and use of nuclear energy, but also to prevent unreasonable risk, both to the environment and human health. The CNSC is also tasked with achieving conformity with Canada's international commitments. And unfortunately, while it's no longer within their mandate, it was within their mandate under their predecessor legislation, the Atomic Energy Control Act, which was to promote the use of nuclear power for peaceful purposes. And so while this is no longer within their mandate, we do see there are still issues questioning their independence, from the industry that they are regulating. And so for many decades, the CNSC has been reporting to Natural Resources Canada, which is also the ministry that oversees those who promote and develop nuclear power, the industry. And so this resulting conflict of interest has been recognized by parliamentary standing committees, by expert panels, and also civil society. And CELA is among those who have argued that there is a need to separate the regulatory oversight from the promotion of the sector, which is found in clear guidance from international bodies like the International Atomic Energy Agency, and the need for the CNSC to be reportable to a separate minister, such as Environment Climate Change Canada. And so the CNSC, they are a body established by law, by statute, and this statute is the Nuclear Safety and Control Act. And this act sets out, again, the purposes of the CNSC as a tribunal, ensuring that they act to prevent unreasonable risk to human health and the environment and conform with international obligations. And this act, the Nuclear Safety and Control Act, also sets out the parameters for licenses. And so should there be a licensing hearing or a license application, it is the CNSC that has to opine on whether the proponent has made adequate protection for human health and the environment. However, we'll contrast that with impact assessment, where Theresa walked us through the process very briefly for impact assessment, where in that context, you consider the need for the project, the purpose, impacts to both the biophysical environment, but also the human environment. Under this licensing procedure, it's a much narrower regulatory hearing. So the CNSC, they've stated themselves, they do not consider nuclear policy or the need for nuclear or alternatives to the project. Again, the test they have to meet is much narrower, and it's whether adequate protection, if adequate measures have been taken to protect human health and the environment and uphold international obligations. And this slide sets out a helpful infographic that just allows you to visualize how the CNSC licensing procedure occurs. And so as you can see, each stage of operations, from preparing a site to constructing to operations to eventual decommissioning or abandonment, those are all separate stages within the CNSC licensing process. And by virtue of being segregated in this way, it poses a barrier. Let's say if you're in the operations phase and a proponent is looking to renew their operating license, it is very difficult, although we try, it is very difficult to raise issues about eventual decommissioning. What will decommissioning look like? Where will the facility, how will it be decommissioned? Where will those parts go? Will it remain in place? Those types of questions. It's very difficult to get the CNSC to turn their attention to, eventual decommissioning and what's down the road, because they are considering an operating license. And so by virtue of having these very separate, segregated licenses, it is difficult for the CNSC to turn their minds to future impacts, intergenerational harm, and distributional effects. And now I will turn it back to Theresa, who is going to speak more about specifics around public involvement.
Okay, thanks, Kerrie. And so now this is, I think, the heart of what we want to get into tonight is, what does credible public involvement in the decision-making around a proposal like the Deep Geological Repository for nuclear waste look like? And CELA, my organization, and our colleagues, sorry, I was afraid I was going to sneeze, developed some submissions back in 2016 when the federal government was consulting the public about what environmental assessment should look like. There were changes being anticipated that were eventually adopted in 2019. And we set out some principles that are still helpful to review when we think about what is the point of public involvement. So it starts early in the planning and decision-making process. It's meaningful, and we'll get more into meaningful as we go with things like good information and transparency, and it builds public confidence. And a credible public involvement process also means that public input could influence or change the outcome being considered. So that's quite an important test. Another important criteria is that the opportunities for public comment are open to all interested parties, that they're varied, that there's different ways to get involved. Some people would like to attend meetings and other people would like to send a comment in writing and everything in between. They're flexible, and they also would involve the public in designing the participation program. And then another important aspect is that the formal processes of public engagement, like hearings or dispute resolution, are clearly set out with principles of procedural fairness, where people know going in advance how the process will work and how the decision will be made, and the threshold for the decision and what to do if they are concerned that the decision didn't meet the threshold. And adequate and appropriate notice is provided would be another important test. So certainly, these are the kinds of things we look for in public consultation and in providing input. If we go to the next, oh, sorry, yeah, you're there already, Kerrie. Some additional parameters or principles for public involvement include ready access to information and to the decisions being made in the local languages that are spoken and understood, that there is assistance in capacity building, for example, funding, available for informed dialogue and discussion to help even out the playing field, where often the proponent of a project, like the NWMO, for example, has lots of money, and those wanting to engage are trying to do something on volunteer time. Another criteria is that participation programs are learning oriented, to ensure that there is learning not only for the public, but also for governments and proponents and participants. Very important criteria is that programs recognize that knowledge is not just held by a small group of people called experts, but the public, especially the public in a particular proposed locale, have extremely, in fact, unbeatable knowledge of the local environment, its history and constraints. And that processes are fair and open for the public to be able to understand the decisions and then accept them at the end of the day, even if they didn't go in the direction they had hoped. Next slide, Kerrie. And I won't read this all out. I'll just make sure that it's in the deck if people want to download it later. But there was a federal panel set up to advise the federal government on how to reform the environmental assessment law back a few years ago. The process I was just mentioning, we had made that submission to about what does it take to be credible. And the panel said public trust and confidence is crucial to all parties. Without it, an assessment approval will lack the social acceptance necessary to facilitate project development. And so that is an important point, that the hallmarks, the kinds of things I was just talking about a few moments ago about what does it take to have a credible public participation, public input process, are not just window dressing, because they have real outcomes in terms of whether the community, such as yourselves, for example, considering this project, will consider the final decision to be credible. Next slide, Kerrie. So dealing with nuclear fuel waste, used fuel waste, is very different from most other kinds of waste that we deal with in our modern society. So we deal with, domestic waste that you and I produce in our household, and we deal with hazardous waste that a lot of our industries may produce or that hospitals may produce. But nuclear fuel waste has some additional characteristics that make it of concern to the international community as a whole. And as a result, an agreement, a joint convention, was reached in 1997 and enforced in 2001, so just about 20 years ago, the Convention on the Safety of Spent Fuel Management and the Safety of Radioactive Waste Management. Because it is an urgent and important global matter to ensure that nuclear fuel waste does not become a hazard to the global community, does not fall into the hands of nefarious actors, and a number of other considerations. And then on top of all of that, it's just plain dangerous to people, the environment, animals and plants, if there is inappropriate exposure to that waste. So it defines disposal as a term of art, as emplacing the used fuel or radioactive waste without ever intending to retrieve it. It requires contracting parties, means the countries that agreed to this convention. So it requires those countries to ensure that society, the environment, and individuals are adequately protected against radiological hazards. It aims to avoid imposing undue burdens on future generations. Electricity is a funny thing because, we have the benefit. I have the lights on here right now, and it's instantaneous. The benefit is to me this minute, and then there's no benefit to the future generations at all from the fact that I had electricity this minute. But the harm remains to be dealt with for basically forever when it's nuclear powered energy. It uses language like suitable measures, adequately protected, reasonably practicable improvements. So there's a lot of judgment going on in terms of how it's managed. But it does say that generation of radioactive waste is to be kept to the minimum practicable. Many of us in the non-governmental community think that it would be best not to keep producing it in any event, that we have other alternatives and we don't have to keep producing such toxic, toxic in unparalleled ways waste. And it provides in that convention that radiation exposure to workers and the public is to be kept as low as reasonably achievable, economic and social factors taken into account. So it's not just that we'll set some standard out there as a number, but that the exposure should be kept as low as reasonably achievable. Next slide. Sorry, I'm a little slow here because I have to advance my slides at the same time. There we go. So what is the role of the international community? Well, in addition to arriving at a convention that sets out these broad and admittedly vague objectives, then the International Atomic Energy Agency, which is the agency that concerns itself with nuclear power, provides guidance to the community of nuclear power producers and provides some benchmarks that we can look at against the current Canadian nuclear waste processes. So, for example, policies and strategies for radioactive waste management stated that the the state should indicate the state's intention to inform the public about proposed plans for radioactive waste management and to consult concerned parties and members of the public to aid in making related decisions. So even at the international level, it's recognized that the public has a very important stake in this decision making. And just like in environmental assessment generally, the IAEA itself is aiming to enhance public confidence in relation to this subject. And it states that decisions which may have a potential health, social, or environmental impact should be made in consultation with those who may be affected. Next slide. And then there's also acknowledgement and reminder that proponents of the nuclear waste projects and the reactor operators themselves also have a stake in public involvement, because they say that public sensitivity, public attitudes and expectations in relation to potential construction of radioactive waste management facilities should be understood and addressed. Experience has shown that transparency and openness by the developer offer the best chance of success, and an important aim should be to gain the confidence and good opinion of the local community. And this, as I mentioned in this slide, is consistent with our often repeated submissions in other nuclear contexts like emergency planning, that if we don't have adequate public consultation and truly meaningful input that has clearly made a difference in the decision making, then we won't have public trust or credibility in the outcomes, which is not, I would say, in anybody's interest. Next slide. Thanks, Kerrie. What are the types of questions and some of the uncertainties that members of the public around a project like this would presumably be concerned about? In other words, what kinds of questions would, and I assume you are asking, I don't have the answers to these questions because I am not the technical expert, but these are the kinds of questions that can be asked and that you should be expecting good, clear, transparent public information about. Let me add here that there should not be confidentiality agreements over this information. It should be publicly available. What kind of hazard or damage could be present and who could be impacted and how could that hazard occur? What are the pathways, for example, for escape of radionuclides? And what would be the potential health effects if things went wrong? And what could be done to prevent that health hazard? And if things did go wrong, what could be done to control that problem? And how can members of the public like yourselves be confident in the answers that are provided? So in other words, how sure are the technical experts about the answers that they're giving you? Next slide. And there are a few areas of uncertainty that are inherent in the topic because of the very long timeframes. We're talking about the thousands and tens and hundreds of thousands of years of hazard. So uncertainties around the properties of the nuclear fuel itself over those very long timeframes is one area of scientific uncertainty that you should be asking about. Another is the behavior of geological formations, because we're talking about, incredibly long timeframes. And the possibility of cataclysmic events, whether those be climate change mitigated or, human mitigated or accident mitigated or inadvertently caused, those have to be explicitly recognized and considered with a high degree of confidence. And then what is the ability of any human technology to withstand environmental pressures over decades, much less thousands and hundreds of thousands of years. And in relation to this proposal in particular, those kinds of questions should be asked and answered with confidence. Next slide. And then another couple of areas of uncertainty that are specific to this technology and its timeframes are around what kind of isolation, containment, protection can be controlled and managed and monitored and kept isolated over those timeframes, and how can the knowledge that goes with that be passed on over those timeframes. And I like to tell the story of a paper that the NWMO put in its very early papers back just when it first started to look into this question, which dealt with this philosophical question called the clock of the long now, building on some philosophical work done before that, where if you think about it, we haven't even really been able to think about timekeeping, which we would consider pretty basic technology in our modern society, that could withstand these kinds of time frames. What kind of symbols could we communicate over that time frame? Will the concept of time itself change? How would you communicate that? And how would you keep track of time if the thing you were measuring is still the same thing we think we measure today? So those kinds of intractable issues include communication issues, technology maintenance, follow-up and monitoring issues. And you know, we're in complete uncharted territory here because there is nothing humanity has done with the specific ability or result to have it last over these timeframes. Next slide. And then there are some other questions and uncertainties that come up vis-a-vis the project that's being proposed and whether that will change over time. So for example, originally it was assumed that the fuel waste would be the CANDU fuel waste based on nuclear technology that uses natural uranium, as we do in Canada. And then we started to have the prospect of Ontario considering new nuclear power and considering other types of nuclear power generation technology. And so maybe those wouldn't be fueled with natural uranium. And if they got into enriched fuel, what new hazards and what new fuel characteristics might that encompass? So that's one example of a change. And now with the push by the federal government and industry to pursue small modular reactors, again, there are additional new fuel types, new fuel hazards, different radioactive characteristics, as well as new non-proliferation risks because of the potential for scattering these things around geographically or whatever might happen. And those come with different management and safety requirements. So we're only, you know, relatively few years into this whole process, and already the fundamental assumptions around what it is that we're managing has been potentially changing. And then the volumes of the project could change. This happened in the hearing dealing with the proposed Deep Geological Repository for low and intermediate level waste that was proposed for Kincardine. That hearing's been withdrawn after SON voted, the Saugeen Ojibwe Nation voted against it. But I was involved with CELA at that project, and we got to that hearing, and these kinds of issues were arising after a completed environmental assessment and impact assessment. And then we were seeing changes in the volumes of waste that were being proposed, as well as the types of waste that were being proposed, because the community in that context had been told that it was low-level waste. Many of them described at the hearing that it was, you know, mops and rags. And all of a sudden, the proponent was admitting that there might be decommissioning waste and there might be other sources of intermediate level waste. So the potential for other types of waste is something that lots of questions need to be asked about and considered as well, because what is the actual shape of the project? Okay, next slide. And then there are concerns about sources of waste. And for example, in the policy that's just been issued for consideration by Canadians to give feedback to the federal government, it isn't stated as a policy that nuclear waste won't be imported. This is an open question that the public should weigh in on. So if we don't want import of nuclear waste from other countries, that's a policy decision the federal government has to make. But from the point of view of a fuel waste repository, can we be sure that this repository won't be taking fuel waste from elsewhere? Next slide. And then we have a context where the United Nations Rapporteur on Human Rights and Toxic Substances did a Canada country visit, well, I was going to say a couple of years ago, but pre-pandemic, and issued a report finding that Canada had a history of inaction on toxic exposure in a discriminatory manner, and specifically Indigenous peoples appearing to be disproportionately located in close proximity to actual and potential sources of toxic exposure. And so this is yet another issue in terms of access to justice and the decision making that is in play about whether or not some of the most toxic facilities will continue to be located in or next door to Indigenous communities because other communities won't take them. Next slide. And then I've alluded to this, but it's worth stressing that the Nuclear Waste Management Organization's documents state that the used fuel waste has to be managed for hundreds of thousands of years, and it's only after 1 million years that it would approach the radioactivity levels of natural uranium. And then if other forms of nuclear power generation are pursued, this may change even those numbers. And the timeframes are such that it's hard to imagine we can have a sufficient level of knowledge to make decisions in any way that we that result in irreversible or irretrievable or irremediable outcomes if things go wrong. And so I just think we need to keep that time frame front and center while we think about providing input to this project. Next slide. So what are some of the remaining ethical and moral issues that communities should be thinking about what they think about? The toxicity is so long lasting and the current energy needs are so fleeting when we have alternatives that there's this question of justification. And then this is in a context, I didn't get into it, but this industry does not have normal liability and accountability for accidents. It has special protection under special laws. Citing fuel waste in northern communities based on economic arguments raises major questions of environmental equity. And from what I've seen, access to information remains a really significant and serious problem. And with that, I will turn it over to Kerrie.
Thanks, Theresa. So Theresa has just gone through a number of uncertainties and questions you can ask. And so now I'm going to provide some suggestions on how do you go about framing these questions and some guiding principles you can rely upon. So the first is the principle of environmental justice. And this principle has a long and complex history. It's a grassroots movement, it's a research paradigm, it's a policy framework, it's a legal lens that we apply and rely on at CELA. And put simply, environmental justice is the idea that the environmental benefits and burdens of an activity should be equitably distributed among all persons, rather than allowing the majority of adverse negative impacts to be unfairly imposed upon visible minorities, Indigenous, or marginalized communities. And so environmental justice is a framework that strives to reorient economic, health, and environmental systems in ways that redress past and present discrimination. And I raise environmental justice today because one of the core aspects of this principle is ensuring the public can participate, which is what we've been talking a lot about this evening. However, we recognize there are a number of systemic barriers that prevent access to justice and true equitable participation. And the difficulties to engagement are many. It takes time and volunteering, or perhaps, like this evening's webinar has tried to provide, perhaps there's not enough resources geared to enabling public participation. There's also inherent power differentials in how decision-making processes are carried out. These can be financial differentials or capacity. For instance, volunteers or nonprofits versus those who are private industry and have capacity for communications and promotion. And so all of these differentials have a compounding effect on participating and the inequities which can become entrenched. And so in advocating for environmental justice, there's a number of procedural dimensions as well. And so we can call these very broadly your environmental rights. And so, the right to participate is a right that everyone have a meaningful opportunity to participate in all aspects of government decisions when that decision could affect your health and the environment. And in practice, this means that you have notice and a chance to share your concerns with the government body that is tasked with making a decision. And so this could be before the Impact Assessment Agency of Canada or the Canadian Nuclear Safety Commission. And also, individuals have a right to know, which means everyone must have full and timely access to information that's actually being relied upon for the decision-making purposes. And so this means there cannot be a differential in what the public knows, but what the government knows, or what the public knows and what private industry knows. And so when we have the same level of access to information, it means everyone can make an informed decision. It's open, it's transparent, and the decision maker is accountable for their decisions. And by advancing environmental justice, you're also engaging in two-way dialogue such that you're voicing your concerns, but the government is also taking into account what constitutes the public's interest. And that is what the government must hear in order to actually carry out their role as well. And ultimately, when the public is able to fairly and equitably engage, it can enhance the democratic legitimacy of the decision that is reached. It can lead to greater accountability and effectiveness of the decision. Often this is known as the social license, and it can produce a better outcome, which is suited to the needs of the community and ensure the community is equipped with an oversight role. And so I mentioned that the right to participate is a core aspect of environmental justice, but in unpacking participation, it's critical that we ask who is participating and who has that right to participate to ensure that the public or communities or individuals are not being left out. So the essential question is, are the people who are being consulted and giving that participation opportunity those who would be most impacted? We have to also ask, are Indigenous and treaty rights being respected? And are all affected communities being consulted? For instance, communities that lie along the transportation corridors. And also, what is that geographic definition that's informing participation? And so these questions are critical to raise in asking who on behalf of a community or who on behalf of a geographic region has that say and has that right to participate. Theresa, do you have anything to add on this point?
Just to say that this will come up at a few different stages. So for example, in terms of which communities are being asked if they're willing, this is a very important question, whether the people who are affected are being asked if they're willing. Much later, if a particular site is proposed and there's an impact assessment, then what will be the study area? And will that encompass the people who are impacted? Or is it being artificially constrained, as we've seen in some other projects where some of the people impacted were not included in the study area?
So now we'll just briefly cover how has the NWMO actually defined this principle of a willing host. And so from the NWMO's the 2021 report, they did set out a definition, and it reads, for informed and willing host, that this is the host community, the local geographic community in which the facility is to be located, and that they must be informed and willing to accept the project. The local community must have an understanding of the project and how it is likely to be impacted by the project, as demonstrate that is willing to accept the project. And I provide this definition just so we see that it is quite broad. However, what our research has shown is that the NWMO's references to willingness, since the NWMO became a creature of statute in 2002, these references to willingness and community have actually decreased in their reports. And a number of the questions about willingness and the concept of consent and getting a community to weigh in, those questions posed in the early 2000s have yet to be answered and remain unaddressed. And so to further unpack willingness, we can look to a range of ethical frameworks and justice principles, such as environmental justice. And these can be used by communities, by individuals, when you're discussing if something is truly, or if a decision is truly willing. There is, our research has shown that there's actually limited empirical research on ethics and environmental justice and willingness that are directly applicable to nuclear waste management in Canada. However, there are some scholars, including an academic from Finland, who have pointed out that more empirical research on how lay people perceive ethical issues relating to community acceptance of a nuclear fuel repository is needed in order to better understand the ethical issues at a local level. Scholarly research has also underscored the importance in understanding the risks to a local community and how that trust mechanism works within their ability to question the process. We have also delved into, is there any cases from the courts that have attempted to define willing in this context? And there is none. And so the majority of case law that considers issues of consent are actually in a different context, like a duty of care between a doctor and a patient, and consent that is needed in that context. So otherwise, we do not have any interpretation from the courts regarding consent in a community context. And so again, trying to unpack what can influence willingness, and this again comes from ethics. And so there's a number of factors, and we've just listed a few of them here. So nuclear stigma is one factor that can influence a willingness determination. And stigma is a worry that a project could negatively impact the name of a community or the reputation of their industries, perhaps their tourism industry. There's also, the nuclear culture. What is the power relationship like between the industry and that community? Is there economic marginality? Is there a culture of acceptance? And we can also look at factors like regional justice or energy justice. And so in that sense, we're looking at, if Southern Ontario is producing the waste and Northwestern Ontario is an exporter of non-nuclear power, what does that mean from an equity lens? So again, thinking about those who are most exposed or at most at risk of this waste in the future versus where it's currently been created through operations. There's also factors such as coercion and consent, and the idea that perceptions of willingness can be skewed when there are other factors at play, such as compensation and also community perceptions of justice. And so this includes distributive justice and dimensions of trust. And again, these are just a number of ethical perspectives that could be applied to this, just to help us further unpack what is meant by the willing host concept. And now I'm going to pass it back to Theresa, who's going to summarize what's yet to come.
Okay, so looking ahead as best we can, the NWMO is engaged in determinations of willingness, and so as mentioned, we have lots of questions to be asked about who is included in those determinations and who is being left out, how it will play into the future steps in the process in terms of who was involved in those decisions, and whether environmental rights like rights to participate, rights to know, and rights to information are being protected in the process on the part of those who would be impacted. And then if there is a proposal, then there would be an environmental impact assessment. So for that purpose, are there information gaps? Are there questions people still have? What has been answered and what hasn't? How reliable is the information? What remains unknown, like sources of waste, types of fuel, what might change in the future? What would happen in the event of an accident or malfunction? And making sure that the exploration of those questions is very thorough, very credible, and completely public. And then if there is an environmental assessment that recommends a project proceed and moves on to nuclear licensing, then that would be an operational regulatory decision, as we reviewed earlier, with a narrower set of questions where the larger decisions about siting and the host community have already been made. And that would be many years in the future if this project makes its way to that stage, where the regulator would look at a certain number of licensing questions in a staged way, as we reviewed earlier, around some of the specific narrow questions pertaining to the site. So I'm going to stop there. I think the next slide. So we have some resources. The first one lists many organizations, both governmental organizations, proponent organizations, NGO organizations, engaged in some way with nuclear waste policy and operations in Canada. A lot of good information there. And then we've also put where our nuclear waste collection is on our website at CELA. And then a few of our colleagues, Northwatch, Nuclear Waste Watch, on whose steering committee we sit, our colleagues at the Canadian Coalition for Nuclear Responsibility and SOS Great Lakes, and then stateside, the Nuclear Information and Resource Service. And I think the last slide just gives you where you can get more information at any time from CELA, the Canadian Environmental Law Association, or the Canadian Environmental Law Foundation, which is a repository for our library, archives, and environmental history, among other things. So with that, I will end the formal presentation, and back to you, Colleen.
Thank you, Theresa. It was a very informative session, and Kerrie. Tyler will moderate anyone that has some questions that you would like to address to either Theresa or Kerrie.
For sure.
Thank you, Tyler.
Yeah, no problem. If there is anyone who would like to come off of mute and ask your question directly to our panelists, you can raise your hand and I'll try and address you going forward. I would ask that if we could just limit your question to one each, because if we have a number of questions, it can be a bit of a challenge to stay on topic. That said, we do have some questions in the chat. I have posted a note in there just to try and use the Q&A feature so that we can follow along. It makes it a little easier when we're going back and forth through this information. So I'll start with the chat questions first, and we'll try and knock those off right off the hop. So regarding access to information, we find that in Northwestern Ontario, some municipal mayors and councils tend to rely on NWMO's preferred information, believing the NWMO to be unbiased. They have an inherent trust, as cited on your slide number 44. This is a great challenge for our organization, We the Nuclear Free North, as we encourage municipalities to seek unbiased info. Do you have any advice on our approach to municipalities?
You know, the fact that the NWMO was set up by statute and the directors are, you know, gigantic utilities who we all rely on in different parts of the country for our electricity supply, means that the context is that people are going to have a lot of trust right off the bat, almost by definition. And but at the same time, we're dealing with a very new question, which no one in the world has solved: what to do with the used nuclear waste. And when nuclear power itself was developed, many things were not understood. The full dangers of radiation were not understood. The level of toxicity of fuel waste was not understood. The potential for accidents was not understood. The potential for you know, the longevity of the waste was not fully understood. So we have to set aside our usual assumption that, you know, oh, they all know what they're doing, you know, they wouldn't be proposing this if it wasn't a great idea, and ask the questions to seek the information. And it's kind of like a kid, like, well, how do you know that? Well, how do you know that? In terms of relying on the industry, a really good idea is to ask municipalities to seek peer review from non-industry experts. And those can be, sometimes they might have to be found out of jurisdiction, because most of the experts, I mean, apart from those of us who maybe engage a lot in the field but aren't ourselves technical experts, you know, most of the experts will work for the industry, because that's where the jobs are. So you might need to you know, look in academia, you might need to look in other countries, you might need to look at some of the civil society organizations in other countries that are big enough to actually have, you know, good level of nuclear engineering on their staff. But peer review is something that in any environmental proposal we commonly see, and if asked for our 2 cents, suggest to municipalities to seek independent peer review separate from the proponent. That's just common in any type of project.
Thanks, Theresa. The next question is: the IAEA guidance states that consultation and engagement that consultation and engagement be extended to those who may be affected. Who defines that group? Is there any additional guidance on how to define that group or what body defines it?
That is a great question. And so right now, a municipality who's considering participating in the process or is participating in the process is one body that could be defining that group and should be, as elected representatives and staff, making sure to define that group very broadly and asking the community and neighboring communities and Indigenous communities who those people are, who those groups are, and then finding ways to consider those who can't speak for themselves, like children or future generations, for example, as well. And then down the road, if the matter gets to the stage of an environmental impact assessment, then if there's a joint panel, for example, that's considering the matter as adjudicators, that will be a question in front of them as well, whether the right people have been consulted and were included in the decision making. Did you want to add to that, Kerrie?
Okay. Thanks, Kerrie. The next question comes from James. If Wabigoon Lake Ojibwe Nation decides not to be a willing host, is the project dead?
Well, one of the problems I've had for 2 decades is that the NWMO itself has not adequately defined this concept of willing host. And but in my opinion, the communities who need to agree are those who, at the very least, are closest to the project, and then additionally those who would be impacted, like on the travel routes and so on. So, you know, I don't have an answer to that question, but if Wabigoon is nearby and not willing, then that doesn't sound like a willing host. The other question is, will the NWMO do what Ontario Power Generation did, which was to make an agreement with the Indigenous communities in that area? This was for the DGR1, the low and intermediate facility, the Indigenous communities who undoubtedly had the traditional and Indigenous rights in the area, to say, if you don't agree, we won't proceed. And that's another way that the NWMO could be clear about that. So not just asking nearby municipalities, but also making it clear that if the Indigenous communities who have inherent rights don't agree, then that project won't proceed.
Thank you, Theresa. Beverly Bannon posted a question in the Q&A. How can I help stop the hazardous waste, I think, into Dryden or near Dryden or into the Northwest, I think is probably a broader question.
Mm-hmm. Well, tonight's presentation has been all about public participation, and public participation absolutely matters. Informed public participation based on principles. So that's the best approach, is to gather information, ask questions, keep track of whether the questions were answered or not. You know, if there were technical documents provided, or if they were said to be confidential and couldn't be provided, which is a concern I have with this project, that is not happening, that there is not adequate sharing of the technical information with the public. Those things should be documented because they will eventually matter in an environmental assessment or other decision making.
And I would just add to that, our final slide, which had all the resources named, it's great to connect with others. So if others share similar concerns, it can be a lot of effort to keep track and keep that list and follow up and dig for answers. And so if there are others you can connect with, you're welcome to refer to our resource slide. And I know there was another question about, can the slides be provided? And we'll post them online, they'll be public. And if a print copy is wanted, we can probably arrange that as well. Yeah. Thanks.
I just posted my email address in the chat there, and if you could flip them over to me, we'll be sure to share them on our website as well, which was dryden.ca/NWMO engagement, as a quick reference for everyone. Another question here comes in from James Kimberly in Atikokan. He asks, can anyone tell me why the monies given to Wabigoon First Nation are confidential? He's tried via email to Wabigoon First Nation on how much they've received, has not received an answer in quite some time. He's contacted the NWMO and asked the same question and was told it's confidential. Using ratepayers' money and taxpayers' money, why is this confidential?
Yeah, I don't think that's something that I can answer for Wabigoon or the NWMO.
Theresa, guidance for James then, like, what would you recommend his next steps be if you wanted to find that out?
Well, so for members of Wabigoon First Nation, and I don't know if he is or isn't a member, then, you know, that's one level of accountability between them and their government, just as it would be for a municipal resident. And then for any one who has the information, who is subject to access to information, like the Federal Minister of Energy, for example, those kinds of queries could be made there as well. Also, those kinds of queries could be directed through some of the public accountability mechanisms, like questions could be suggested to members of parliament to be asked on the order paper, and then you know, the researchers try to get an answer unless there's some reason they can't. So I'm not saying I don't know whether it could or could be answered that way, but those are some mechanisms.
Thank you. See another question in the chat there. So from Brenane, there's significant aspects of NWMO project which are still in the design or concept stage, such as the used fuel transportation package or the used fuel packaging plant, where high-level waste will be transferred from the transportation package to the long-term container. The NWMO has repeatedly announced that it will make its site selection in 2023. So by default, the NWMO is expecting the community to make its demonstration of willingness before that selection. Is it reasonable to ask the community to decide if it is willing to accept a project which is still in the concept/design stage? Similarly, in the NWMO siting process, the selected community will enter into a formal agreement with the NWMO in step 6 after the community decision on willingness. Is it reasonable to ask the community to decide if it is willing to accept a project before it knows the details of the formal agreement with the NWMO?
So this goes to the heart of what informed consent is, or a willing host. If you consider a willing host to be another version of informed consent, if key parameters of the project are not yet known, then obviously there's no informed consent. It's not yet known. The information wasn't shared. The technical risks were not shared. So, you know, were I to be a resident of the community or a member of the community, I would want that information before making that decision. And I would want any decision I made or any agreement I made to have an out, you know, if further information indicates that there are risks that were not known when the original decision was made.
Kerrie, anything to add to that?
Just to add, I think it raises a good point about the chronology of the events. And so, like Theresa said, the willingness is being entered into and then an agreement, but it's the impact assessment stage where it's very critical that all those technical studies are underway and that sharing of information occurs. And impact assessment by its very nature is, you know, you look before you leap. And so it's asking all those upfront questions before any development occurs. And, you know, it's a multi-stage process, there's early engagement with the public. And so a lot will come out from that, but that comes after, well, in the current order of things, that is proposed to come after the willingness determination is made and that agreement entered into.
Thanks, Kerrie. Another question coming.
So just to be clear on that, Tyler, I think we're agreeing the town should have, and so should Wabigoon and Ignis and any other town, South Bruce, any community should have that information before they make the decision.
The next question from the chat kind of goes into that a little bit. If a municipality has identified themselves as a willing host, yet the project site is not contained within their municipal boundaries, do they have some type of decision-making primacy over other municipalities or Indigenous communities? And that question comes from Shane McKinnon.
Mm-hmm. Well, I've had concern about that all along, that you know, here's a context where municipality is being asked to make a decision about a site that's not located within the municipal boundaries. And that's why I was at some pains to talk about the limits of municipal decision making in the first place. But even beyond that, the municipal decision can at best be an indication of an opinion by a neighbor, as opposed to having any sway over the location in particular over which it has no jurisdiction.
I actually have a question for you, because I don't see any populated yet, but I'm sure there'll be some more to come. Let me just pull it up here. So how you posted a slide up there that had a little visual of the licensing processes that the CNSC kind of goes through, and you mentioned that they're kind of siloed in the sense that they don't talk to one another throughout the process. Who and
yeah, it's not that they don't talk to each other, but what happens, and we've been through these for lots and lots of different types of nuclear facilities, is that they're very definitive about what it is, the CNSC, the regulator, what it is that's in front of them for that type of a licensing decision. We have the opinion that it should be much more connected. So for example, when you have renewal of an operating license, we have argued that you should still consider whether the site itself is adequate. This is for nuclear power plants in populated Ontario. We've made this argument to no avail. Similarly, as Kerrie mentioned, when you're considering the suitability of a site or a later stage operating and so on, you should be considering repeatedly what's the decommissioning plan for the site. And apart from some very generic consideration of that for the purpose of setting up financial assurances, it's been very disconnected. Yeah, so, but on the other hand, it's, you know, for sure, when you get to the next stage, they're going to talk about what happened before, but the relevance of what happened before might be quite constrained to the new stage. Yeah.
All I was going to ask is who defines that process, or how is that process created?
It's basically through the Canadian Nuclear Safety Commission has this process of consulting on what they call regulatory documents about how they make the kinds of decisions they have to make. And they do that on a cycle. I think they try to get to all of them every 5 years or so, although they say they'll take input anytime on how well it's working. And but in any event, you know, they'll come out with a regulatory document about decommissioning and what factors go into that decision, or a regulatory document about operating a nuclear power plant, or safety assessment and what factors go into that. So they're the ones. It's the commission members who are the 5 or so members who've been appointed by the government to be the commissioners, who must approve the proposal provided to them by their staff generally. And there usually is public consultation on that.
Okay, so the framework is designed how?
The licensing framework is designed by the Nuclear Safety Commission.
Okay. We have some questions from the chat in here. So Lynn asks, if an EA process proceeds for one of the 2 sites and the site is turned down at the licensing decision stage, what will happen at that point? Will they reopen the learn more stage again and restart the process?
Yeah, that's not something I can predict. Yeah.
Okay. Nisha asks, I'm from Ojibwe Nation of Saugeen, number 258 near Savant Lake, next to Ignace. I would like to invite Kerrie to participate on a panel on the safety of nuclear waste on Indigenous lands, and please email her, and her email is in that question there, Kerrie.
Thanks. And I will pop our email addresses in the chat box. I guess I didn't mention at the beginning, but I am the Northern lawyer for CELA. And so I'm based in Northern Ontario and Robinson here in Treaty Territory. And so, yes, while CELA operates province-wide, I do get the privilege of living and working in the North. So thank you, Nisha, and I'll put our emails in the chat box. So if others do want to follow up as well, you're welcome to reach out to either Theresa or I.
Thank you. Renee asked another question. We observed in the environmental assessment process in hearing for Ontario Power Generation's proposed Deep Geological Repository for low and intermediate level radioactive waste, now withdrawn, that important issues that the CNSC considered to be related to the operating license, such as the term safety and such as the long-term safety and the long-term performance, were not fully considered in the EA hearing. This meant that those longer-term safety issues were deferred to future licensing hearings. Can you comment on this limit to the impact assessment process in terms of looking at a longer-term safety and performance issues?
Yeah, this is something that's fairly unique to the nuclear context, in my observation, that the environmental assessments are being constrained over some of these fundamental safety and performance questions. Normally in environmental assessment in other sectors, we do get into those to a reasonable level of detail. It's an artifact of this industry that they've been trying, and the regulator's been trying to keep the environmental assessment limited to more high-level issues. And we've tried to litigate that question, for example, around the proposal for new nuclear at Darlington. And we were partly successful in the courts and then unsuccessful at the end of the day, where the courts said it was within the jurisdiction of the regulator to run that process the way they did. But to give you the context of what I'm talking about, one of the issues there was that the type of waste to be generated by new nuclear at Darlington was not within the scope of that EA. And similarly, the consequences of very high consequence accidents was not within that EA. It was bounded to a much smaller accident, and those kinds of questions, to the extent they were looked at all, were deferred to licensing. So, yeah, it is a problem for sure, and it means that it's kind of the opposite sort of decision making that we normally want to see in environmental decision making, where instead of having a really good solid information base and then just refining the details and working away the uncertainties as we go forward, we're starting the process with these really big uncertainties and bumping all of the real questions down the road all of the time from, in this case, if it proceeds the way it's laid out here, from this willingness determination to the EA to the licensing. And if things happen in this process the way we've seen in the DGR at Kincardine, the Darlington hearing, and so on, you could end up with a context where you're still getting down to willingness was decided and impact assessment was recommended, you're at licensing, and you're still not getting to what you would consider the really fundamental questions around safety. So, public participation and speaking up about the information you want right now at this willingness stage, I think is even more critical because of that strangeness about nuclear decision making.
Thanks, Theresa. Kerrie, do you have anything to add to that? Okay, great. There's another question in the chat. I'm not sure if we're going to be able to answer this one. Chief Kavanaugh from Treaty 3 said in a media statement that he will decide if the DGR goes ahead, period. And do you guys have anything to add to that, or any guidance on that statement?
Nope, that's not something I would speak to or speak for.
That's what I thought, but nevertheless, we'll address it.
I can
Jody
just
has a
add on a periphery note, under the Impact Assessment Act, we have talked a lot about impact assessment tonight. And so I thought I would flag, this is newer legislation, came out in 2019. There is the capacity under the Impact Assessment Act for other jurisdictions to lead in the impact assessment process. And that could be a band council, it could be an Indigenous governing body. However, that has to be enabled by a regulation from cabinet. That hasn't yet happened. This is another issue that CELA has been working on, but I will just flag it at the impact assessment stage. There is the ability for, in theory, an Indigenous-led impact assessment, although that tool has not yet been triggered under the law, but it is something to think about.
Thanks, Kerrie. Jody asks in the chat, Dryden is more likely to be negatively affected by the DGR rather than Ignace, given that Ignace is at the head of the watershed. How does a community like Dryden ensure that they are considered by NWMO as a major community who should have the right to reject the NWMO's project?
So in addition to making those points to the NWMO itself, it's also really important to be making the points at the same time to political decision makers as well. So because this point about credibility of the process is something that, you know, municipal, provincial, and federal decision makers all care about and that matter. So if a community that's going to be impacted is not having a say, then that needs to be raised to the NWMO, but also to the Minister of the Environment, to the Impact Assessment Agency of Canada, etc.
Thank you. I don't see, oh, we do have another question. What input can another country such as the USA have in this process?
Yeah, that actually came up in DGR1, where the study area I alluded to earlier was, in my opinion, too narrowly defined and did not include not only surrounding Canadian communities, but also did not include American communities on the other side of the lake. And as a result, a huge amount of involvement was undertaken by state governors and mayors and civil society and others in the US, and it was raised as something to be looked at by the International Joint Commission, and letters were written by, you know, governors to premiers and so on and so forth. So, you know, we have a shared waterway and shared environment, and you know, the question about who's impacted needs to be considered in that context.
Thank you. Just 1 second, I just got to read a quick. Sorry about that. That was just a quick message from Roger Nesbitt, CEO of the City of Dryden. He just wanted to extend his thanks for your wonderful presentation this evening, and really appreciate you guys taking the time to answer all these questions. I know we'll probably have a few more afterwards, and they'll keep streaming through. So I have one. You touched on it briefly in your presentation, but small modular reactors are in a state of growing concern in Canada. Currently, they're being investigated as a potential way that used nuclear fuel can actually be reprocessed and used to fuel small modular reactors. Is CELA involved in this discussion at all? And at what point are you at in that discussion?
I'll let Kerrie speak to that. We are engaged in the policy discussion on small modular reactors and on radioactive waste policy, as I mentioned. And So, oh yeah, so Kerrie's put in the chat a link there. We have one concern, for example, is that small modular reactors have been argued to be an essential component of the fight against climate change. But we're quite concerned that that's a diversion of important public resources and time that we don't have in the fight against climate change for an unproven technology. And then the other two major concerns are, well, three really, but around the different characteristics of waste that would be produced in small modular reactors, depending which one's chosen, because of the different characteristics of the fuel. And then a really major concern about nuclear risk, non-proliferation, terrorism, the potential for diversion of materials. And I personally think that that has been inadequately understood by the federal decision makers in considering this technology. But Kerrie, did you want to add to that?
Sure. Going back to one of the assumptions you spoke about earlier, Theresa, was when the NWMO first began its public consultations on, what should we do with nuclear waste in Canada? It did assume a finite amount of waste, which is from CANDU reactors. And so now to go back to communities and say, well, it wouldn't just be CANDU waste, but how does SMR waste fit into that? And was that ever agreed to? And did that ever inform the process leading up to this? And so this question of what would be done with nuclear waste, again, there are small modular reactors, they only exist on paper, and there's hundreds of designs. They vary in size from 1 to 300 megawatts. Small is industry's term, and modular is also industry's term, that there's this hope that they can be manufactured in factories and delivered as is to a site. And the sites proposed are mine sites, First Nation communities that currently rely on diesel generation. And so they would be deployed, and that's industry's term. So these SMRs would be deployed in hundreds of locations in order to make them cost effective. And when you do so, you are introducing nuclear waste to a much wider geographic expanse, to remote areas without roads, areas that are only accessible by plane, for instance. And so there's fundamental questions that have to be addressed and have not yet been addressed by nuclear proponents as to who oversees that waste, how will it be dealt with within the existing framework. And those answers haven't been forthcoming. So the link we shared in the chat box is kind of a catch-all webpage where we house all of our work on, or not all, but a majority of our work on small modular reactors. There's webinars on there that we've recorded and posted. There's even, if you're a member of a group and you want to sign on to a statement opposing small modular reactors in Canada, there's a link there. You can sign on. We're currently up to 120 groups from coast to coast to coast who are opposing federal investment in SMRs. So definitely relevant to tonight's discussion about nuclear waste and asking those questions. What are the characteristics? What are the sources? What are the pathways? And SMRs are definitely part of that conversation.
I just want to thank Bernine for posting some information in the chat too, and follow up to some of the questions as well. So appreciate that, Bernine. Another question from Nisha comes in. First Nations have treaties with First Nations that protect their lands that ought to be the first in consultation. Provinces and municipalities have no power of jurisdiction. The government has overlaid First Nation rights with the layers of laws that don't apply to First Nations. This is how they have made First Nations as third parties in decision making after their lands as resources. But more of a statement. No problem, Nisha, no problem. I don't see any other questions coming in. Pauline, do you see anything on your end that I potentially may have missed? One from Bernine.
Tyler, no, I don't want to extend Pardon me?
All good, no problem. Bernane posted a question here. Some have speculated that centralizing the waste, such as the location of a deep geological repository, would facilitate the reprocessing of the waste. In addition to the proliferation risks, operational experience has also shown that reprocessing is highly contaminating activity with many additional environmental impacts. Under the CNSC licensing process, would it be possible for the NWMO to apply and receive a license for a deep geological repository and then add a reprocessing facility to the site?
I think what I would say is that in my experience, things can always change. And so if it's important to constrain the activity that the community is agreeing to, which I would say it is, because you're being asked to be a willing host, or Ignis is being asked to be a willing host, I guess, and you're a neighbor, and the First Nations similarly, any indication of willingness about anything should be extremely defined, and there should be extremely ironclad boundaries around that.
Thank you for that. Colleen, I don't see any other questions being posted at this point in time. Anything, closing statements, anything like that you would like to add?
I'd just like to thank our panelists and host here for the excellent presentation, the information, and also for the public participation. We really appreciate that in the interaction and the questions. Just to remind the public and everyone that we will post this to our website. And Tyler, maybe if you could post my contact information as well, just if anyone had a question afterwards, they could certainly send it to myself, and we could forward it on to the appropriate people to get an answer for you to the best of our ability.
Colleen, if you have access to the chat, maybe just throw your email address in there, and that should suffice.
Well, thanks for inviting us. It's always really great to hear people's questions, and one of the things we do is public legal education, so we remain available for that in the future.
Greatly appreciated, ladies. It's been a pleasure to chat with you here this evening, and look forward to the next opportunity to do so.
Great.
Thank
Thank you again. Good night.
Good night. Bye, everyone.
Good night.